Divorce is handled by state law. If you were under the jurisdiction of a state by that own state's rules, you can get divorced in that state. That doesn't mean you must get divorced in that state. Theoretically, it's possible to get divorced in one of many states depending on you and your spouse's residency and ties to those respective states. But for this article, let's just consider Florida versus Illinois divorce laws. I, personally, am licensed to practice law in Illinois and Florida and have focused my two practices, one in both Illinois and Florida, on the family law in particular. If you've read either of my blogs, you'll see that I'm kind of obsessed with family law. Jurisdiction of divorce in Florida. Florida has great weather, low taxes and tough jurisdiction laws. To get divorced in Florida, either you or your spouse must be a resident of Florida. To be a resident of Florida, you must reside in Florida for at least 6 months of the year. If either spouse has spent 183 days of the current year or the past year in Florida, they are a Florida resident for the purposes of divorce. If anyone contests those 183 days, you must prove via calendar that you were in Florida during that time. Honestly, your phone probably can prove exactly where you were if you're inclined to ask it. Jurisdiction of divorce in Illinois. Illinois has a bad reputation for not accommodating businesses, but they sure accommodate divorce. You only have to be in Illinois for 90 days to get a divorce in Illinois. That's not 90 days before filing, that's 90 days before the actual divorce. They're used to a lawyer in Chicago who would only advertise in the Philippines, where it is illegal to get a divorce. Filipinos would take a long vacation in Chicago and 90 days later they would be divorced. The Philippines would then have to recognize that Illinois divorce due to treaties between the Philippines and the United States. For more colorful Chicago divorce stories, please ask me as I have a million. What happens when jurisdiction is contested between Illinois and Florida? When jurisdiction is contested between Illinois and Florida, the two respective Illinois and Florida judges schedule a judicial conference, which most people know better as a phone call. The two judges then discuss the practicality of proceeding with the divorce in their respective jurisdictions. So which is better for divorce, Illinois or Florida? It really depends on the facts of your divorce and what your interests are. Let's go through each of the main factors in divorce. Division of assets in Florida versus Illinois. Florida law requires marital assets to be divided 50-50ths. If those assets are not divided equally, the court must explain why in written findings. Explaining why you didn't follow the default law in written findings is essentially asking to be appealed and overturned. Alimony or spousal maintenance in Illinois versus Florida. In Illinois, there is no alimony. Instead, people receive a large sum of money every month that is, instead, called spousal maintenance. As Shakespeare said, "A rose by any other name would smell as sweet." Illinois has guidelines spousal maintenance. That is, the large earner pays the small earner 33% of his or her income minus 25% of the small earner's income. This is all pre-tax money. There is a cap, though. You cannot receive maintenance, including your income, beyond 40% of the total income of the couple, together. So, for the mathletes out there, if you make more than 150% of the income of your spouse, you will pay your soon-to-be ex-spouse some kind of spousal maintenance. Child custody in Florida versus Illinois. In both states, child custody is determined through the standard, the best interests of the child. How the courts arrive at the best interests of the child in both states is usually done with the help of an outsider. In Florida, a child custody evaluator is appointed to meet with both parents, the children, and anyone else associated with the case. The child custody evaluator is usually a therapist, child psychologist, or some other professional whose professional expertise can be relied on by the court. Child support in Florida versus Illinois. Child support in Florida is determined based on the parties' incomes and the time that each party spends with the child. If a parent spends more than 20% of the time with the child, that parent will get a reduction in any child support owed based on the percentage of nights the child is with the parent. In Florida, each parent who pays for health insurance or childcare then gets a credit against or for the child support owed. So where should I file my divorce? Illinois or Florida? The law really isn't dramatically different between the two states except for alimony or spousal maintenance. Illinois has a set formula to determine the amount and length of spousal maintenance. Florida has no alimony formula for amount or time. This means that in Florida, you are really relying on the quality of your attorney to set your alimony. For most people, if you're paying alimony, you want to file for divorce in Florida. If you expect to receive spousal maintenance, you'll want to file for divorce in Illinois. The division of assets in Illinois is more flexible than it is in Florida. So, if you think you have a good argument to get more than 50% of the marital estate, you'll want to file for divorce in Illinois. If you want to lock in a 50-50 split, you'll want to file for divorce in Florida. As far as child-related issues go, you don't really have a choice. You'll be locked into whatever jurisdiction that your children have lived in for the last 6 months. If you'd like to speak with an experienced family law attorney who is licensed in Florida and Illinois, do not hesitate to contact me.